I'd like to start and
Yes, please. Yes.
introduce everybody to. Yeah. So, namaste to one and all. Thank you for participating in this joint endeavor of Think India and Human Rights Defense International e-certificate course on human rights. Today, our session is about International Convention on Social, Cultural, and Economic Rights, 1860. And our speaker today is Advocate Mugdha Pande, ma'am. Thank you for taking out time, ma'am, for this session and being present here. I'd like to introduce our speaker for today to everybody. Mugdha Pande is a practicing advocate in Delhi and also appears before high courts of Bombay, Chandigarh, Bilaspur. She is a versatile lawyer and works on a range of matters pertaining to civil, criminal, labor, as well as constitutional law. She is a junior counsel in the chambers of Advocate Mahesh Jethmalani and has worked on some of the most impactful cases in the recent past, including the Navtej Singh Johar versus Union of India case, which is the decriminalization of homosexuality, the Reserve Bank of India versus Punjab National Bank case, Rohingya refugee crisis, to name a few. She has completed her LLB from SOAS, University of London, and BA in Political Science and Archaeology from St. Xavier's College, Mumbai. With this, I'd like to request ma'am to kindly address the audience and start the session.
Firstly, thank you, Medhavi, for the introduction. I'd first like to start by welcoming all of you. Thank you for taking the time and attending the session. I hope in the end you find this useful. I'd first like to thank Ganesh, Shashank, Vedansh, and the entire team of Think India for organizing this seminar and for inviting me to speak on this topic. Think India is one organization that I'm most proud of to be associated with. It gives opportunities um, to students to access internships and apprenticeship opportunities with top senior counsels, with top law firms, which they otherwise would not have gotten. So I'm extremely proud of the kind of work Think India undertakes, and I hope they continue doing the great work that they have been doing. I'll first start with introducing the International Covenant on Economic, Social, and Cultural Rights. I'll start with a bit of history. I also want to talk about the International Covenant in light of the labor amendments which came about recently, especially the one by the UP government. And we'll analyze the amendments in backdrop of the articles and the rights enshrined in the covenant and the interplay of it. So first I'll start with a bit of history of ICE SCR. Now ICES, the International Covenant, let's just say for the sake of the seminar, is one of the principal international human rights treaties. It is a primary international instrument that defines and seeks to enforce economic, social, and cultural rights. Now, these rights are aimed at fulfilling certain tangible needs such as food, water, shelter, as well as providing access to cultural life of the community. ICE SCR is a multilateral treaty ratified by most of the UN member states. Now, the International Covenant came about after the UN, in the sense that following the devastation of the World War II, the UN was created in 1945 and they were tasked with reaffirming faith in fundamental human rights, in getting all the countries to commit to basic principles of human rights and to make this world a better place. Now, in order and as an exercise to further that objective of reaffirming basic fundamental human rights and making every country on earth to adopt those, this led to the creation of the Human Rights Commission in 1946. Commission drafted the Universal Declaration of Human Rights, which was announced by the UN General Assembly in 1948. Now, while the UDHR provided an aspirational and comprehensive declaration of rights, it did not have any legally binding force at that time. Therefore, the Human Rights Commission was therefore tasked with drafting a covenant that would elaborate on the rights in the UDHR and give them legal authority, give the UN legal authority to enforce those rights on the countries, on the member states. So the covenant requires a formal state ratification, meaning consent of the member states would be required before any binding obligations can be imposed on them. Now, India ratified this treaty ratified this covenant in 1979. Now, a little backdrop to this this covenant is that it is a sibling covenant of the International Covenant of Political and Civil Rights. Now, due to political differences in the UNCHR, they were not able to create a single comprehensive binding covenant. The backdrop of this issue is that while they were framing this covenant, there was our world was going through a Cold War. The Western Bloc wanted the economic, social, and cultural rights to be separated from the political and the civil rights, whereas the Soviet Bloc wanted the political, civil, economic, social, cultural rights to be one comprehensive, to be a part of one comprehensive covenant, because they thought that they were inseparable and interrelated, and creating two separate covenants didn't really solve any purpose. Anyway, in the end, we know which side prevailed, and now we have two international covenants. The great majority of the covenant on economic, social, cultural rights goes towards realizing Article 25(1) of the Universal Declaration, which is that everyone has the right to a standard of living adequate for the health and well-being of himself and of his family, including food, clothing, housing, and medical care and necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age, or other lack of livelihood in circumstances beyond his own control. Now, these provisions are further elaborated in the articles of the International Covenant on Economic, Social, Cultural Rights, and you'll find the elaboration in Article 9, 11, 12 of the Covenant. And the unemployment benefits and labor market programs seek to realize Article 23(1) of the Declaration and Articles 6 and 7 of the Covenant. So the aspirations of the UNDHR is seen elaborated through these two international covenants. So the UN gave a very broad idea of its aspirations, and covenants are specifically furthering those aspirations of the Universal Declaration. Now, I'll first start with Article 1, which I think is very interesting, and I'll tell you why very soon. So, Article 1 states that all peoples have the right to self-determination. By virtue of these rights, the peoples have a right to freely determine their political status and freely pursue their economic, social, and cultural development. Now, India, Bangladesh, and Indonesia are some of the countries which have made reservations and given interpretative declarations to their application of this covenant. So, India interprets the right to self-determination as applying only to the peoples under foreign domination and not to apply to peoples within the sovereign state. Now, so agreeing to Article 1 of the treaty, in its entirety would have meant giving consent to secessionist actions. Now, the reason why it's important to understand this reservation put forward by India while ratifying the treaty in 79 is that it has a backdrop in 1963, and it has a very strong source in our constitution. Now, in 1963, Article 19(2) of the constitution was amended, and the words "the sovereignty and integrity of India" were inserted in it, creating one more exception to the right to free speech. Now, Article 19(2) of the Constitution confers powers on the state to make laws to impose reasonable restrictions on freedom of speech in the interest of the sovereignty and integrity of India. So when you hear secessionist slogans, many a times, in the extreme left, some of the extreme left education institutions, especially in the capital of our country, and the people who support these secessionist slogans and such as secessionist ideas do that under the misconception that they are protecting freedom to speech, our constitutional right to freedom to speech, which is completely incorrect. And these people should perhaps go and read the constitutional amendment, especially the 16th Constitutional Amendment Bill of 1963, introduced by Pandit Nehru himself, who said that, who also called this 16th Amendment of 19(2) article of our Constitution as an anti-secession bill. It was designed to prevent local political leaders in different regions within India from using the electoral process to even peacefully propagate secession from the Union of India. The chief target of this amendment back in 1963 was actually DMK, the political party in the South, who were advocating secession of some parts of the South and create a separate nation called as Dravida Nadu or Tamil Nadu now, but they wanted to create a separate state for the Dravidian race. Similarly, at that time, the Union of India was tackling with secession calls from Nagaland, from Punjab. Therefore, the reservation given by the Indian state to Article 1 of the International Covenant on Economic, Social, and Civil on Cultural Rights of 1966 is to be understood in the context of the 1963 amendment of our constitution. So we cannot ratify a clause that goes directly against our country's constitution, and hence the reservation which was placed by India on accepting the narrow interpretation of Article 1. Now, I also wanted to talk about on the International Covenant on Economic, Social, and Cultural Rights in light of the recent amendment on labor laws by few of our Indian states, especially Uttar Pradesh, Madhya Pradesh, Gujarat, particularly Uttar Pradesh because it was quite in the news. Now, one of the criticism of these labor amendments by, for example, Uttar Pradesh government has been that it violates our obligation made to the International Covenant on Economic, Social, and Cultural Rights. I want to first explore the parts of the labor laws in the UP ordinance suspending some of the labor laws, and then I will talk about its application and its interaction, how it interacts with the International Covenant. So the state government of Uttar Pradesh specifically has suspended close to 30 labor laws post COVID-19 situation. It has led to an unprecedented economic meltdown. The unemployment rate is one of the highest in the last few decades, and there is an urgent need to tackle the unemployment and the economic crisis. And as one of the measures to tackle the economic situation in our country post COVID lockdown is to attract more businesses in our country, especially the ones which are wanting to leave China or have expressed a desire to leave China and find an alternate um, country to explore economic opportunities. So one of the measures, or one of the reasons the state government thought of suspending um, the some of the labor laws is because they are of the opinion that by suspending these laws, it will give certain flexibility, it will give an impression of ease of doing business in our country, and would perhaps facilitate these foreign companies to open their businesses in Uttar Pradesh and in India, so that we can find employment for these, like for the millions of laborers who are out of work. Many businesses had to shut because of the economic situation in our country. So if you actually read the ordinance, now the ordinance has suspended about close to 30 labor laws, but it is a temporary suspension of 3 years, and it has not suspended the basic rights necessary for fulfilling our obligation under the International Covenant for Economic, Social, and Cultural Rights. Except for trade unions. So then, what has been kept under the ordinance, under the exemption, under the suspension ordinance of labor laws in the UP? Number one, provisions relating to safety and security of workers under the Factories Act of 1948 has not been suspended. Building and other construction workers regulation of Employment and Conditions of Service Act has not been suspended. Child Labor Prohibition and Regulation Act, Maternity Benefits Act, Employees Compensation Act, Equal Remuneration Act, Bonded Labor System Abolition Act has not been suspended, including Section 5 of the Payment of Wages Act. Now, Section 5 is the right to receive timely wages. Besides these exceptions to the exemption ordinance, all the businesses owners will have to abide by certain conditions in order to start business in the state government. Now, first is that all the business owners will, the name and details of all its employee workers will have to be entered electronically in the attendance register, so that the state can keep a track on who is getting employed, their details, and their interaction vis-a-vis the employer. Second is so they can monitor, the number of employees employed by a certain company, and who has been employed, and so on and so forth. Second is no worker shall be paid less than minimum wage as prescribed by the UP government. Third, the wages shall be paid promptly within the time limit prescribed by Section 5 of the Payment of Wages Act. Fourth, wages shall only be paid to their bank accounts. Fifth, provisions regarding safety and security of workers prescribed under the Factories Act 1948 and Building and Construction Workers Act will remain intact. Workers shall not be allowed or required to work for more than 11 hours a day. Compensation for death or disability due to accidents arising out of or during the course of employment will be covered under the Employees Compensation Act of 1923. all the labor law provisions relating to women and children will remain applicable. Provisions of Bonded Labor Abolition Act shall remain applicable. So, um, despite temporarily suspending quite a few labor laws, the UP government has kept intact, I, in my opinion, the crucial economic rights of workers and their families, except for the trade union, which I will talk about in my later part of the speech, which ensures our country's obligations under the International Covenant on Economic Social Rights. Um, Now, the suspension of one labor law, that is the suspension of the Trade Unions Act, and has created the most uproar in the media and politically, and the one making the most noise on suspension of the Trade Unions Act is, of course, the Communist Party of India. Now, frankly, in my opinion, the trade unions have become more of a political fiefdom that work more towards holding businesses and political institutions to ransom than actually further the benefit of individual workers. I have worked on many matters pertaining to labor laws, and the labor unions have time and again failed the individual workers covered under the trade union. So frankly, um, I feel trade union was a very redundant institution, and I do not feel that suspension of trade unions temporarily is in any way a violation of a fundamental human right. Now, let us analyze these amendments in the backdrop of the articles under the International Covenant on Economic, Social, and Cultural Rights. Now, I have already spoken about Article 1. Article 2 and 5, Article 2 to 5 talk about non-discrimination clause and state that the rights under the covenant should be exercised without discrimination on the basis of race, religion, gender, sex, language, political opinion, etc. Now, the Equal Remuneration Act of 1976, which has not been suspended, even in a state like UP, which is highly criticized, remains intact. And neither is Article 15 of our Constitution. Now, no statutory, no statute can override a constitutional right. So, Article 15, which is of non-discrimination, is covered under is covered even if any other labor law is suspended. Therefore, Article 2 to 5 on non-discrimination does not. So the country, even when a state like UP has suspended labor laws, we are still meeting our obligation under the International Covenant on Economic, Social, and Cultural Rights. The second part is Article 6 and 7. Article 6 and 7 recognizes the right to work, that is, a right to opportunity to gain his living by work, which he freely chooses. Now, due to the COVID-19 situation and the lockdown has led to many businesses shutting down, and as a consequence, many of our citizens have been rendered unemployed. So I'd say if a state government is making an attempt to attract business without compromising on the basic socio-economic rights, which may lead to temporary suspension of other extended economic, social, cultural rights. However, if such an act is preserving the essence of Article 6 and 7 by ensuring that a worker in his state keeps his dignity intact by attracting business, by making an attempt to attract business, by giving him an opportunity to go seek work and earn his living by working, instead of just handing out some packet of food. I think, in a sense, we are by suspending labor laws in order to attract business. I think we are, in a sense, fulfilling our obligation to Article 6 and 7. Article 7 particularly states that all the signatory states shall ensure one, equal and fair minimum wages and without any discrimination. Like I just said, the UP government has not suspended Equal Remuneration Act, and I'm using UP government as an example. Why? Because I think by far out of all the states, they have had the most radical ordinance, wherein 30 labor laws through an act of one ordinance have been suspended for a period of 3 years. So I'm using UP as an example in my speech. UP government has not suspended the Equal Remuneration Act or the Employees Compensation Act, nor the Section 5 of the Payment of Wages Act. Therefore, Article 7 saying that we need to ensure that the states are obligated to ensure equal and fair minimum wages. I think even the ordinance, even the ordinance suspending labor laws, even then, I think we are still meeting our obligation under Article 7 of the International Covenant. Second, the part of Article 7 is that states need to ensure safe and healthy working conditions. The UP government has not suspended the provisions relating to the safety and security measures provided under the Factories Act and the Builders and Other Construction Workers Regulations and Construction Workers Act. The maternity benefits is still intact. Therefore, therefore, we are still meeting our obligations under Article 7, subclause 2. Article 8 is about trade unions, and the ordinance passed by the state of UP does clash with Article 8 of the International Covenant on Economic, Social, and Cultural Rights. But there again, they have not been perpetually scrapped. They have been temporarily suspended in the hope that it would attract business, it would provide employment, it would give every worker in that state who's rendered unemployed a chance to earn and live a dignified life. So I feel a temporary suspension does not lead to an outright violation of our obligation under Article 8 of the International Covenant either. Now, Article 13, Article 9 is about the social security and social insurance for workers and employees. The central government has, in several rounds recently, held discussions on providing a national level social security service to employees in the unorganized sector, which, according to data provided by the Economic Times recently, covers 90% of the 500 million workers that we have. So only 10% are actually are covered in that employer-employee fund scheme, whereas as per our current laws and provisions, 90% of the workers from the unorganized sectors are left without any social security. So the state government has, in fact, right now accelerated and fast-tracked their discussions with the Employees Provident Fund Organization and the Employees State Insurance Corporation to provide social security, which could benefit millions of people, including like taxi drivers, delivery service people like on Swiggy or Uber or Zomato, or day-to-day domestic helpers who are not covered under the organized sector and they don't really benefit from any of these pension schemes or employee wages schemes, and then they're rendered helpless. So the central government is aiming at covering these individuals also under this new law which they want to soon introduce. Article 10 the Article 10 covers maternity leave and benefits, protection of children and young persons from socioeconomic exploitation. So Child Labor Prohibition Act and Maternity Benefits Act, both laws are not suspended even by the UP government by their recent suspension ordinance, and therefore we are still meeting our obligation under Article 10. Now, we have to. It's very important to understand what these rights and articles under the covenant mean. Now, similar to our constitution is basically an aspiration of our people that this is where we want our country to be, where there's there's an absolute equality, there's no discrimination, there's uh, everyone has a freedom to religion and cultural rights. Now, by adopting constitution, when we adopted our constitution in 1950, it did not automatically eliminate the social economic evils in our society, right? I mean, it's an everyday struggle. Every day, the rights. And every day people move the court to enforce these rights. So we have come a long way. Similarly, when we talk about the rights or the obligations under the International Covenant on Economic Rights, on those are aspirations. I mean, we are still a developing country. Um, there is no government or of any state who wouldn't want to provide, who would consciously want to deny their people of the fundamental rights to all the who would want to deny their citizens fundamental economic rights. But we have to understand these rights in the context of the political situation the political situation in our country, across the globe, the economic situation our country is in, our priorities given the uh, given the pandemic. So when we ratified this covenant, that we made a promise to strive to fulfill each of our obligations. So there is no malice, there is no mens rea to actually deny the workers in India any of the rights which the treaty obligates us to do. It is that given the situation, certain states have felt that perhaps in order to compete with China, in order to attract more business and try to resolve the economic crisis that we are in, sus- perhaps suspending certain labor laws which are seen as cumbersome and hindrance to businesses may be lifted, so that every worker is at least given an opportunity to go and seek work. Um, that's about I wanted to actually talk about that because the focus of my speech was mainly on the amendments to labor laws in certain states in light of the International Covenant on Economic, Social, Cultural Rights. So with that, there are a lot of other so International Covenant covers a lot of other rights like right to education, which we have guaranteed, right to primary education, which we have inserted as an amendment in our constitution. Uh, so we are moving towards there has I don't think anyone can actually say that our country has failed to attempt to meet the obligations. Yes, we have had to suspend a few economic, social, cultural rights depending on the social political situation, socio-economic situation of our country. But overall, I would say India has made every attempt to fulfill its obligation under the International Covenant on Economic, Social, Cultural Rights. So I feel that the criticism is slightly misplaced. With that, I would like to end my speech, and I'm just open to questions now.
Yeah, so we'll take questions now. You can just put that in the chat box if anybody has a question. let's wait for 2 more minutes. If somebody's typing, it may take some time. So so we have question from Akash Desai, which is, do you think that the suspension of trade union will have an impact on grievance redressal of migrant workers?
I'll address Akash's question first. I think so. This question is: do you think that the suspension of trade union will have an impact on grievance redressal of migrant workers? I said absolutely not. Trade unions was not a platform where the workers could actually meet their grievances. In theory, it might. In theory, a trade union is supposed to represent the grievances of the workers, but in reality, it is far from it. I mean, from my experience in labor law practice, the trade unions have completely failed its members, and if they have any grievances, courts are always open, right? I mean, their basic our constitutional rights are still intact, no matter which the law is suspended. No ordinance can has to be compatible with the basic structure of the constitution and fundamental rights. No one can suspend fundamental rights. No one can suspend constitutional rights. So every right which is protected under the constitution, will remain intact. And the workers always have the court to approach whenever they have any grievances. And so yeah, and there's always a there's a labor department which addresses grievances of the workers. I feel that way an individual worker will not have to sacrifice his interest in the interest of a union, or it may not get sidelined. Every individual's right, I think, will be addressed. So I think it's better that in this situation, I think that trade unions are not the go-to organization for workers anymore. So I'm actually happy about suspension of trade unions. Second question is, don't you think the suspension of certain
We have another question from Aditi Bhatt.
She says that, don't you think the suspension of certain laws, such as those which regulate working conditions and contracts with labels, no quote exploitation by contractors? No, and I'll tell you why. So I'll tell you the laws which are not suspended. I had read out the certain acts which are not suspended, even by the suspension ordinance. One is the Child Labour Prohibition and Regulation Act, not suspended. Maternity Benefits Act, not suspended. Employees Compensation Act, not suspended. Equal Remuneration Act, not suspended. Bonded Labour System Abolition Act, not suspended. Section 5, which ensures wages to be provided in a timely manner, not suspended. Provisions relating to safety and security of workers under the Factories Act, 1948, not suspended. So, and they have created further provisions that if you want to benefit for the businesses, for them to benefit out of these suspended labor laws, they will have to create an online portal, create a database of every single worker that they are employing, transfer their salaries directly to their account so that you can keep a track of who is getting paid what. Right now, there is no such system. I mean, even if the minimum wage, for example, is say 50 rupees an hour, the way which a construction factory worker actually gets in his hand is way lower than that, and there is no system or no data or no method to monitor and track. So I think these provisions, especially the UP government provisions, I'm saying, and I'm constantly referring to UP provisions because they have the most radical suspension of labor laws in comparison to any other state. So even the most radical one right now has not suspended any of the basic fundamental economic rights of the workers. It has in fact ensured that they are covered through these conditions laid down for seeking benefit under the ordinance. So yes, so I don't think under these laws, under the suspension laws, I do not think that that would make laborers any more prone to exploitation than they already are, for sure. Um, the second question, so the first question actually is, how do you see the media giving selective coverage to suspension for labor laws in UP? Well, um, I think, see, there is um, I, I don't think a lot of people have actually read about what the ordinance is. There needs to be more debate um, um, in like on the public platform about what the ordinance is about. Just merely by stating that they have suspended labor laws, it's extremely exploitative and it will lead to further exploitation of workers and children and women. That's not true. I think you need to go and read the ordinance, read the conditions laid down in the ordinance. So yeah, I think it's important. I think the onus will be on the government, state government also uh, uh, to speak to publicize what ordinance actually means, so that even the workers know what rights will remain intact even after suspending certain labor laws. It's very important to spread that message to an individual worker, and that onus I think will be on the government. So we can't really. I mean, media is something which is not in anybody's control. What we have in our control is the state machinery to ensure we are communicating and communicating with our with the state subjects and with the employees and workers from the unregulated sector. It's important that they get to know what their rights are. So I don't think media usually matters in this situation, as long as they are able to make sure the workers actually get to know their rights.
We have another question from Kaustubh Singh Thakur, and he says that after the UP government issued the ordinance, a PIL was filed before the Allahabad High Court. The UP government later withdrew certain parts of the ordinance. So, what could be the possible reasons for withdrawing if the basic laws were kept intact?
They withdrew certain provisions of this ordinance. Um, See, I've not read that case, and I do not know the reasons for withdrawing it. Could you, if the person was actually asked this question, if he could elaborate on what they have withdrawn or what was actually challenged in the PI, I could probably look for legal reasoning for that.
Okay, so we'll wait for a reply, but then we have other questions. We have one from Aryan Kalra, who says suspension of trade unions will lead to no definite MP and will lead to uneven price in the market. So will both workers and consumers may suffer? I mean,
No, not necessarily. Trade unions have got nothing to do with price of a product. And secondly, when it comes to basic wages of an employee, the state government has laid down conditions in which they say that they are going to fix a minimum wage, and they still have. I have already laid down the acts which are not which will continue to be enforceable even under the suspended ordinance, the exceptional acts. Um, so yeah, trade unions have never decided the price of a consumer good, and there is no data to say that they've actually um, have that they have actually been very effective in protecting the interest of an employee. Because I have seen so many examples before whenever I've argued in a labor matter that trade union has been the case forwarded even for the employees. They prevent them from actually voicing their individual grievances, which might not be compatible with the majority of the workers. And so a lot of personal individualistic issues get sidelined under trade union. I'm not saying that trade union is completely um, uh, you know, should be done away with. But the manner in which many unions function in our country is doing more harm than good. So that's all I have to say.
Okay, then that's about it. I think we've covered all questions that we were supposed to take. Um, I think that's it. Yeah, we're not getting any more questions. So thank you, ma'am. I'd like to give a vote of thanks for before we end this session. Thank you so much, ma'am, for taking out time for the session and enlightening so many young minds today. The fact that you correlated everything with what's happening currently, sure, must have been very informative and enriching for many. On behalf of Think India and HRDI, I extend my heartfelt gratitude for the session. I would also take this moment to thank our many Think India student activists who have been recording, testing, and coordinating with all the participants to make this course happen today, and to all the participants who are participating in this course. Once again, thank you all. We would end this session now.
Thank you, ma'am.